So, Renato, did the Supreme Court just hand Trump a free pass to deport anyone he wants to El Salvador?
Eh, it's complicated. I'm Renato Mariotti. I'm a former federal prosecutor, a practicing lawyer, and a legal analyst.
And I'm Asha Rangappa. I teach national security law at Yale University. I'm a former FBI special agent, and I'm a legal and national security analyst.
And we're here to help you understand topics that can't be boiled down into a soundbite or a skeet.
Whoo boy, there is a lot happening, and it's happening really fast.
Yes, perhaps faster than it should, because the Supreme Court is really, getting its hands in the mix very quickly regarding these deportations to El Salvador.
So, should we do just a quick recap of the procedural posture of this case when we last left it?
That sounds good.
Yeah. So there were Venezuelans who were already in detention, who, after Trump made a proclamation that the United States was being invaded by Tren de Aragua, which had already been designated as a foreign terrorist organization, these people were all rounded up, and because they were ostensibly members of Tren de Aragua, rounded up, put on planes, and destined for a prison in El Salvador. 5 of those people were still in Texas, and they brought suit in district court in the district in Washington, D.C. There were also several plane loads of people, and also a lawsuit was brought on their behalf. Justice Boasberg in D.C. issued 2 temporary restraining orders. One was to bar the removal of the plaintiffs that were in Texas, and the other was to turn the planes around that were already on their way. Now, importantly, these claims were being brought under the Administrative Procedures Act, which basically allows people to bring suit against agency action. And basically they were saying the Department of Homeland Security or the Secretary of, Homeland Security doesn't have the authority to do this, and is acting arbitrarily and capriciously, and just there's no basis for them to choose, or the way that they're choosing the people that to go is arbitrary. And so that was where we left it. The Trump administration appealed those TROs. The DC Circuit upheld it, and then they appealed it to the Supreme Court. Separately, back at the ranch, they never turned the planes around. And that made the judge mad. So there was a whole other set of hearings on whether the Trump administration was in contempt of court. And Judge Boasberg has not, I don't think, made a ruling on that particular issue yet.
Yes.
Is that all? Is that a good summary of
That's a
where
great
things stood?
summary. That's a great summary. And I think it's important for people to understand the APA is a law that's been around a long time. And it's, I think, since the 40s. And it is a sort of a mechanism that you use to challenge what regulatory agencies do, basically, making sure that their actions and and broadly speaking, are fair and clear and so forth.
And just to also emphasize one aspect, because it's going to become relevant in a second, as I mentioned, there were 2 sets of plaintiffs. There were the 5 plaintiffs who were in custody in Texas. But what Boasberg did was he certified a class. Like, he basically made everyone else, not even just the people on the plane, but basically anyone else who could potentially be subject to this proclamation and this removal, into a class to which his TRO applied. So, it was going to be prospectively prohibiting the Trump administration from applying the Alien Enemies Act in this way against anyone, really.
Right. And a couple things too. First, everyone should understand, we talk about TRO, we're talking about a temporary order from a court that essentially keeps things, keeps the status quo while the case is going on, so that this way no one is harmed in a way that can't be undone. I mean, you don't want to have a situation where, because litigation takes so long in court, that the government, for example, just whisks everyone away to El Salvador and can't get them back. And so you want to do what you can to keep that on hold. And also, I would say that, having a class of everyone involved, and impacted by those decisions, is a very economical and efficient way of handling this from a judicial perspective.
Yes, and one of the factors in issuing a TRO is whether there's going to be irreparable harm, and also whether there's a likelihood that that party is going to succeed on the merits. But yes, being sent to a foreign gulag is sort of irreparable, we
It's
think.
pretty
And that's actually
irreparable.
that's
Yes.
another question that we're going to get to with another case. But okay, so then this goes up to the Supreme Court, and the Supreme Court on Monday, I think, vacated both of these TROs and essentially said that you can't bring this claim under the Administrative Procedures Act because what the as I understood it, the court was saying essentially what these people are doing is challenging the legality of their detention. And when you're challenging the legality of your detention, that is a habeas claim. You're effectively making a petition for a writ of habeas corpus. You're forcing the government to explain the legal basis, and a habeas claim has to be brought in the jurisdiction where you're being held. And when we talked to Steve several weeks ago, we talked about this, that because a habeas petition is effectively the jailer has to show up in court and say, here's why I'm holding this person. You have to go to where the jailer is. And at least for the 5 plaintiffs, we know that that is in Texas because that's where they are. But there were a couple of hundred people who landed in El Salvador. So query where they file. We'll get back to that in a second.
Mm-hmm.
And then, of course, this also means that because there's no longer this TRO against all of these people as a class, the Trump administration can basically resume its removal proceedings, the summary removal proceedings. The court says they have to give everyone proper notice and an opportunity to file a habeas petition. So they did emphasize that everyone is entitled to judicial review. But I don't know where that leaves things, given the way that the Trump administration is handling this. I mean, they are clearly, it seems like their intent is to whisk these people out and then say, oopsie.
Yeah, a couple things. I mean, this is a very excellent explanation, kind of laying this out, Asha. I think that, first of all, it's important for everyone to understand. This is, I think, a perfect topic for this podcast because, on its face, the court didn't. What they did still gives everyone an opportunity to have due process, right? But the reason I stressed the efficiency of it a minute ago when we were talking about what Judge Boasberg did is that, of course, what this essentially means is that every person will have to have their own proceeding that's individualized, that they're going to have their own lawyer making their own arguments about their own situation. That's much more burdensome for the courts, but it's also more difficult for individuals, right? They actually have to exercise their rights and have a lawyer and present this to a court. And as you point out, the bigger issue, of course, is what about people for whom they're all like it's already a fait accompli, so to speak, where the administration takes them away? Will they have an opportunity? And I suppose it'll be interesting to see what the courts do here, because on its face, what you see from the courts, in fact, Justice Kavanaugh wrote a separate opinion saying, "Hey, all 9 justices agree with due process. It's just how we achieve it here." But if you have a case of, let's say, a case brought on behalf of someone who's in El Salvador, what is the Supreme Court going to say? Well, no venue in it, in this court or any other court in the United States because the person's not here. Very interesting question.
So apparently, there is habeas case law that suggests that when detainees who are entitled to habeas are located outside of the United States, the proper venue is DC. So, in the Guantanamo Bay cases, for example, all of those detainees, when they were granted habeas rights, they all went to the DC district court. So, I guess those people can all file, but as you know, Renato, now there has to be a habeas petition for each individual person. And this here, I think what's complicated, one interesting thing is, at least in this for this set of plaintiffs, these people were already in detention. And so it does seem like for people that are already in the government's custody, I don't see what stops the Trump administration from first getting them all to Texas or
Mhm.
some favorable venue and then saying, okay, we're going to now deport you. You can file for habeas. In other words, the government sort of in that kind of situation gets the first shot at determining where the best venue is for them. It
Mhm.
also seems like if they are arresting someone off the street, I mean, it's not really clear from the Supreme Court's decision. It's not like they're saying this has to be some kind of Miranda warning, right? Where at that moment they're like, you can call your lawyer to file a habeas petition. I mean, it seems like they can take them into custody and once again whisk them to some facility somewhere, and like in Texas, say, and then tell them that they have the ability to file habeas. So in other words, it just seems to me to give a lot of control to the government on where to allow these to be filed. But even if they didn't, imagine the inefficiency of this, of having hundreds of habeas petitions in district courts all over the country. Because again, the habeas question is directed at the individual and the reasons for that person's detention, as opposed to being directed at the authority writ large of the agency to be able to do this at all.
Right, the agency action more broadly. Yeah.
Mm-hmm.
Um, really, I mean, really important and interesting questions. One thing that I'll just note is you mentioned the administration selecting its venue. That really ties into a discussion that we've had in the past, and I believe we discussed that with Steve Vladek when he was on our podcast about private litigants choosing venue, right? Going to these random courts in Texas where there's only one, filing and where there's only one judge and getting the most favorable person. This is a way in which potentially the Trump administration can do that writ large, right? Say, okay, we're going to move everyone to this facility in this particular district where we know we have a favorable court of appeals, and thus we'll have it's a very favorable record when we get up to the Supreme Court. But then secondly, the if they move everyone to the same facility before deportation, you can imagine flooding the courts so that you have effectively a circumstance where all these habeas petitions are backlogging a small court that doesn't have a lot of judges, essentially, effectively denying them due process, not formally, but as a practical matter. It's sort of like how, we've talked in certain contexts like reproductive rights about how, well, you technically might have the right to exercise your ability to get an abortion in a state, but there's no center to get it, no provider, or only one provider who's several hundred miles away. This is similar, like you technically have the right to file your habeas petition, but 5,000 people are all trying to file in, Lubbock, Texas, and it might take you 2 years to get a hearing.
I will say, Renato, there is a little bit of irony here because it then turns out that the Trump appointed judge to which the men in Texas then petitioned with their habeas petition actually then barred the Trump administration from transferring or removing those men or any other Venezuelan citizen held in the Southern District of Texas who are subject to deportation under Mr. Trump's proclamation. So that was a Trump appointed judge. And then there was another judge in New York where subsequently somebody filed a habeas petition who also barred the removal. So, I mean, I think we need, I don't think we should try to suggest that just because it's in Texas, the judges there are not going to consider these. But it is, as you said, it's a matter of like the number and sort of some relative friendliness. And I saw a great thread on Blue Sky, which I'd never heard this term before, where he talked about how the Supreme Court can engage in what he calls channeling, which is using these decisions that on their face seem like they're just procedural or, just sort of a legal technicality. Like this is a habeas claim. It's not an APA claim, but in that way, essentially steer cases into certain venues that are more likely to get to certain outcomes. And I think in this case, the other piece to highlight, and I know you were talking about earlier with me about the dissents in this case, to make it harder to bring systemic relief. In other words, to make it harder to bring a class action. And I believe that I think you can. There is an attempt by the ACLU to file a class action habeas lawsuit. I am just not at that in the weeds of habeas law to know how likely that is. From what I understand, it is very rare that you have a class action habeas. So in other words, this is a much narrower relief, and also it won't allow for systemic change. And the Supreme Court can kind of do that through this, in this sneaky way.
Yeah, look, that's why this is a good topic for our podcast. It is really something where you have to think about the shades of gray. For example, something that maybe our listeners can relate to is there are times where you have a theoretical opportunity to get something. Maybe you have to send in a postcard. Maybe you have to fill out a form and write a letter or something, whether it's a refund or whether it's a rebate or something like that. A lot of times you aren't going to do it, right? Because
Yeah.
just there's costs associated with it. Whereas if you just have to click and press a button on your phone, you're much more likely to do it, right? Similarly here, just every obstacle that's required, whether it's getting your own lawyer, filing your own case, going through that process, that can create a burden, right? And then separately, just the burden that it places on courts um, are important. And this is, I think, to get back to some themes that you and I have talked about. I mean, I think you're a big believer, Asha. You've always been about how procedures matter.
Mm-hmm.
And this is an example of how the type of procedure you go through can have an impact on the outcome. And it's worth noting, since you talked about the dissents, I thought Justice Jackson's separate dissent was quite striking, because one thing that she raised there, talking about procedure, is how this is another example of the Supreme Court using its emergency docket to reach a very speedy result, not using the ordinary procedure that it would undertake, where you would have oral argument and everybody would be heard. And this is what, to harken back to Steve Bladdock, the professor we've talked about before, has been a guest. He refers to that as the shadow docket, and is, I think, carefully chronicled the rise of that, the use of that emergency and expedited, not full procedure by the Supreme Court.
Right. And I think especially so in this case, because there was a pretty major legal decision made here, right? That this is not a claim that can be brought under the APA. This is a claim that, sounds in habeas. And I think Justice Sotomayor talks about that too, where she says this requires a little bit more explanation. In
Mhm.
other words, this is, actually kind of a major change to the understanding of these kinds of claims. And it's being done, in this emergency docket to lift these TROs, as opposed to arguing on the merits and getting full briefs on the legal arguments for and against that. I thought she made a really interesting point that Habeas claims, the purpose of them, like the relief that's being sought, is release from custody. In other words, you're in jail, you petition for habeas corpus, you're saying this person has no legal basis to hold me, they have to let me go. And if the writ is granted, that means that they have to let you go. But what she says is these people were already in custody. Like, they were already being detained. That's not what they were asking for. They were basically saying this is just illegal action by the government. And so she's like, so I think there's actually a legitimate question here on whether the APA applies. And, the majority has sort of just summarily decided that the APA doesn't apply, and nobody really knows exactly why.
Yeah, and you say summarily, that's a key word there, because if you read this opinion, it's very short. It really doesn't get into the weeds of the APA and why it doesn't apply here. And it really does appear to represent a shift in the case law. And yet, you can imagine when courts and litigants are trying to make sense of this, there's not a lot there for them to hang their hat on, precisely because of the procedure that the court took, where it didn't have full briefing and is rushing out an opinion on a very expedited basis.
So we will see. I mean, I think one thing the court does say is that even in these individualized petitions, these detainees can challenge the applicability of the Alien Enemies Act to them. So presumably some of these questions, not only about how is the government determining who is a member of this group, but I would think even the larger question of whether Tren de Aragua could constitute an invasion, which I think is another relevant question, is something that could be brought. It is going to, again, we might end up with 30 different opinions on that, because all of those questions will be answered in all of these different courts. Obviously, ultimately, the Supreme Court will have the final say. But my point is, I think some of those questions are still on the table. The government isn't necessarily off the hook, for that.
That's an important point that you make in there as well, Asha, is that one consequence of having these decisions made on a case by case basis for individual movements, or bringing these cases, means that you could very well have a patchwork of decisions that don't entirely line up with each other. Much different than having one single decision about a kind of a practice more broadly that ultimately is decided by the Supreme Court and impacts everyone equally.
Right. So we'll see. I suspect because of how quickly the government is moving, that some of these questions will be answered sooner rather than later. So I guess we're going to come back to it.
Yeah, stay tuned.
Stay tuned.
If you're interested in these cases, then that's great. You're going to hear more about them. That's because they're important. Ultimately, if the administration can whisk people in the United States off to foreign prisons, that could impact all of us. And so you should care, even if it's not one of your friends or relatives that are part of the initial group.
So, Renato, to pick up on the point that you ended with, I think that's gets to sort of the other big case right now that's pending. And we're recording this on Thursday, April 10th.
Yeah,
So
April 10th.
it is possible this will get resolved in one way or another before people hear this. But to your point about how it should concern us all, there is another case concerning Kilmar Armando Abrego Garcia, who was actually under a court order barring his removal to El Salvador, but was picked up anyway and sent to El Salvador.
And
Go ahead.
I was just going to say, what's remarkable, I believe I'm remembering correctly, this is the case in which the government lawyer admitted that mistakes were made. and that he should not have been removed, which is remarkable because it actually appears that he is now facing his own disciplinary action effectively from the Justice Department, a person who was touted by the Trump administration recently in a promotion, because he exercised appropriately his candor to the court and was truthful about what they were doing.
Right. He told the court asked him whether this was an error and whether there was any legal basis that authorized his removal, and he said to his knowledge, no. And he was put on leave for that. So, that's
Yeah.
a whole other thing that we can get to, which is, the punishing of people. And it seems like, I guess the administration expected him to lie to the court.
Yeah, I mean, in fact, I think what was said was that he wasn't zealously advocating, right? Or is it what the stated reason was for being placed on leave? And I imagine that if he was our guest on this podcast, he would say that he was exercising his candor to the court to say the truth, which is that this was an error. And it really does hook into, as you mentioned, what we said at the end of the last segment, which is if somebody can be mistakenly removed and there's no, obvious recourse there, and the government's going to lie about it to the judge, what's to stop them from removing Asha Rangappa next week?
Nothing. There's literally nothing. And so, in that case, the judge ordered the government to bring him back. And this is where the government initially said, you have no jurisdiction over, the warden of this El Salvadorian gulag. And the judge says, no, but I have jurisdiction over you. And I'm going to order you to do everything in your power to get this person back. And that order is now under review by the Supreme Court. And I think that one will probably be one of the most consequential decisions for exactly the reason that you just mentioned, Renato. Because if the government can snatch someone up, send them to El Salvador, and then say, oh, yeah, we made a mistake, but there's nothing we can do about it. And the court's answer is, yeah, you're right. Too bad, so sad, mistakes were made. Then really, I mean, who needs SEAL Team 6? When you've
Sure.
got whatever his name is, Hogan,
Hmm.
whatever, that DHS guy who, is so excited about rounding people up. Yeah, he will go around vacuuming people up left and right and sending them to El Salvador. And I don't think he cares whether you are a US citizen or a legal resident or whatever.
Well, and just to tie this back um, to the last segment that we were talking about, ultimately how the Supreme Court handles this, there's going to be shades of gray that could potentially impact the Trump administration's ability to take advantage of that. In other words, what exactly can a judge order the administration to do? How is oversight over that? How can they enforce those orders? um Ultimately, if the courts, I have a very ineffectual oversight over the executive, the Trump administration may just do it anyway and let the courts clog with a bunch of individualized case, challenges from the 1,000 people that were on the plane, and potentially have judges struggling to, do something about it.
Yeah, what I foresee here that the court is going to have to grapple with to kind of bring this back to the immunity decision and this whole idea of the unitary executive. I'm going to be giving a lecture later on today about how those theories are impacting what's going on. Is that the court's order, the lower court's order, is essentially you need to go negotiate with the El Salvadorian government to get this guy back.
Hmm.
And negotiations with other heads of state is really a core executive branch authority. In other
Right.
words, your discretion and in fact, the confidentiality of those types of negotiations are completely protected. They're within this, Article 2 cone, right? People used to ask, how can we not get the translators' notes from Trump's conversations with Putin? And, you can't. Even George Washington refused to turn over his diplomatic cables with foreign governments to Congress. So, like, in other words, I foresee there being some struggle in the Supreme Court with this very pro executive branch, unitary executive majority on how you would justify a court telling the executive branch how to negotiate or what to negotiate with a foreign government. I mean, don't you? I think there is a completely plausible path that the majority, will say, yeah, sorry, we just can't step on those toes. And it's not our within our purview to question or even review what the executive branch is doing in that arena. What do you think?
It, I think it's possible. I think it's also possible, and this is what I was trying to allude to earlier, that there'll be shades of gray. I mean, in other words, even if a court could order the executive branch to try to negotiate, how can they possibly oversee the effectiveness of those
Right.
negotiations? It's like, what if the Venezuelan government's like, we offer, we want, some concession in return, or we want some money in return, or we want our tariffs to be lowered in return, or whatever that might be. And the executive branch is like, no, we've decided that returning Asha to the United States is not important enough to be worth this minor concession. And
Right.
so we're not going to do that. And how can a court review that? How can a court force the executive branch to make a deal with a foreign government? So that's a huge problem.
Well, and how could I could see the government just coming back, the Trump administration coming back and saying, yeah, they won't do it.
Right.
We're not going to tell you why. That's privileged communications. That's
That's
covered.
possible as well.
In other
Yeah.
words, to not even like, we tried, but it just didn't work, but we can't tell you why. And they are going down this road, right? Like, I do that would be an executive privilege claim. They've already done the state secrets claim in the contempt proceedings that are the contempt hearings that they've said, well,
Hmm.
we can't tell you when the planes left and when they landed because that's a state secret. So, there's all these different ways. I think you're absolutely right that at some point the court would have to give deference to the executive branch in, even if they were to say we can order it in terms of the ability to do it at all. Um, Although I see that then cuts perhaps against the administration in the long run, right? Because if then the government is basically saying, once we do this, we have no power to get these people back, that does argue for a much more robust restraints, more robust due process before the government is ever able to remove anyone from the country, precisely because of the likelihood of error and the irrevocability of it.
Yeah, I mean, obviously, there's an interplay between this and our last topic, right? In other words, could you imagine a circumstance in which this becomes more widespread rather than a lone case, and then the Supreme Court is looking at a broader challenge? But I think it's interesting. I don't know if we made this clear, but in the last segment when we were talking about that decision, Justice Barrett notably did join the dissent for some key portions of it. For a substantial portion of the dissent, she was not in the majority in that case. Um, but really, this is going to come down to what is Chief Justice Roberts comfortable with and what he's willing to do. But I think it goes even beyond deference to the executive branch, Asha. It actually goes to the core capability of the courts to enforce and
Yeah.
oversee what the executive branch is doing, because I think it's a challenging thing to force people to negotiate anyway. It's hard even in the United States. If me and you are in a lawsuit in New York or Chicago, having a judge trying to say, okay, are you trying to engage in good faith settlement negotiations? Like, how do you even know? Like, and here, if you could have an administration trying to negotiate, how is the court can even know? I
Totally.
think, yeah, very hard, very hard.
Yeah. And I think all of this comes back to our government really rests on people acting to some degree in good faith. Like they
Yeah.
respect the prerogatives of the other branches and they know, okay, I got to tell the truth to the court.
Yeah, I
I have
mean,
to obey court orders. And so if you're dealing with bad faith actors who are trying to find ways to undermine and evade the authority of the other branches, it is a very uphill battle, I think.
so, if we're gonna talk at a very high level, 10,000-foot level about the difference between Trump 1.0 and Trump 2.0, we talked about the two administrations. Trump 1.0 would kind of stumble into ways in which they could find hacks around the Constitution or the rule of law or system of laws and so forth. Trump 2.0, it's had 4 years to dream up ideas of how it's going to accomplish these things. And nonetheless, I'll note it is not doing so in the most effective way to achieve its goals, which is giving courts an opportunity to review this in lone cases of one person for whom there's been an error rather than floodgates of people. But nonetheless, it's definitely presenting more difficult challenges for courts. And this is ultimately, and I don't think it's overstating this, Asha, that these decisions are ultimately going to determine whether courts are a meaningful check on the executive branch in particular, aspects of its authority going forward.
Yeah. I think to just close, and this is sort of where I'm going to close with my lecture today, so I'm thinking about it. We have to remember that just like with the tariffs, you know, uh, this is all happening under delegated congressional authority. I mean, theoretically, conceptually, uh, not even conceptually, practically, um, Congress could repeal the Alien Enemies Act. Like just say you don't have the authority to do this. I mean, they're not going to, but my point is he is getting this from Congress. And uh, there is a way for Congress to claw back some of these powers that the Trump administration is abusing so as not to only leave the judiciary in the position of being the one to have to stop it.
Yes, and we'll note that that is um, 18 months before elections that could determine the control of one or both houses of Congress. So, Asha, before we go, I'm very pleased to announce and break the news that Henry will be contrarian pet of the week this week. It's very exciting news in the Mariotti household.
Wait, what? Pancake has been in line forever.
Yeah, this is just
For
yet
real, like
another.
for 2 months ago, I was like, when is Pancake going to get to be pet of the month? They were like, oh, in a few weeks, and then I think I forgot, but now I have to go and follow up.
Yes. So yeah, Henry is well, this is just another demonstration of the superiority of dogs over cats, which can be debated in the comments, I suppose. But Henry is very excited. He is growing up and becoming a very serious young man.
Mm-hmm.
He's engaging in a lot of Paw Patrol outdoors at our place. So this is a very exciting accomplishment for him.
That's great. Is he politically engaged?
Yes, yes. He might get, he is because he's such a patroller. I think was considering enlisting and joining in, DHS or one of these agencies, but we've dissuaded him from doing that in the current environment. So
Okay. Okay. Um, Pancake not so politically engaged.
he doesn't seem engaged at all. He's like actually, he seems to me like he'd be like a beach bum
He's a
or
beach
something
bum.
like that. Yeah,
Hmm. Yeah, he
yeah.
likes to watch a lot of reality TV. A lot of nature shows or whatever. Um, yeah.
Yeah, I mean, Henry is like absolutely all business. I mean, he is. We're gonna get. I think we're thinking about for Halloween. We may get like a police uniform for him because he is all over our property constantly. He's watching out for everyone. He doesn't have like other dogs anymore because they might encroach on our property. And
Oh,
he is, yes, and he's all serious all the time. Like, where's the treats? Where's the food? What are we doing? Why aren't you in bed yet? All that good stuff.
okay. Well, then the fate of democracy is in Henry's hands. Pancake is not going to be helping.